Welcome to EUPrivacyForAll, Session 61 on GDPR, Articles 68 and 69 EDPB. Article 68 on the European Data Protection Board and 69 on its independence lay down several provisions. Article 68 lays down that the EDPB, so-called the Board, is established as a body of the Union and shall have legal personality, which is different from Working Party 29. The Board shall be represented by its chair. It shall be composed of the head of one supervisory authority of each member state and of the European Data Protection Supervisor. Where in a member state more than one supervisory authority responsible for monitoring the application of the GDPR, a joint representative will be appointed. The Commission will have the right to participate in the activities and meetings of the Board without any voting right. The Chair of the Board shall communicate to the Commission the activities of the Board. The European Data Protection Supervisor shall have voting rights only on decisions which concern principles and rules applicable to the Union institutions, bodies, offices and agencies. Article 69 on the independence of the EDPB lays down that the Board shall act independently when performing its tasks, without prejudice to requests by the Commission regarding guidelines, recommendations and best practices in order to encourage consistent application of the GDPR. The Board shall, in the performance of its tasks or the exercise of its powers, neither seek nor take instructions from anybody. As laid down in Article 68, Recital 139 announces that the Board shall promote a consistent application of the GDPR and act independently, have the legal personality, be represented by its chair, and should replace the Working Party 29. It should consist of a head of a supervisory authority of each member state and of the European Data Protection Supervisor. The Commission shall participate to the Board's activities, and the EDPS should have specific voting rights. Finally, the Board should contribute to the consistent application of the GDPR throughout the Union, including by advising the Commission, in particular on the level of protection in third countries or international organizations, and promoting cooperation of the supervisory authorities throughout the EU. Directive 95/46 lays down in Article 29 on the Working Party that Working Party 29, on the protections of individuals with regard to the processing of personal data, shall have advisory status and act independently. It was composed of a representative of the supervisory authority or authorities designated by each member state, and of a representative of the authority or authorities established by the community, institutions and bodies, and of a representative of a commission. Where a member state has designated more than one supervisory authority, already a joint representative was nominated. What should accountable data controllers and processors get prepared for? As for Article 29 Working Party, the Working Party 29, the European Data Protection Board, the Board, is composed of the head of one supervisory authority of each member state and of the European Data Protection Supervisor. Each member state has a voting right, and the Commission has no voting right. The Board shall act independently. Contrary to the Working Party 29, the EDPB is a body of the Union, it has legal personality, the European Data Protection Supervisor will have voting rights only concerning principles and rules applicable to the Union institutions, the EDPB will replace the Working Party 29 when the GDPR comes into force. The Board will advise the Commission, in particular on the level of protection in third countries or international organizations, and promote cooperation of the supervisory authorities in EU. So the question triggered now is, will the EDPB legal personality and new status as a body of the Union favor a more consistent and practical regulation across EU?